All right, good morning.
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 Let's have everybody that is participating in this round turn their camera and their mic on real quick. I want to make a conflict check and ensure there's no issues there. Good morning.
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 Let's have everybody that is participating in this round turn their camera and their mic on real quick. I want to make a conflict check and ensure there's no issues there. Morning.
Oh, shit. I was washing my face. Does it look bad?
You guys hearing a delay? I think that might be the live stream.
Yeah, I believe so.
Running. Muted or turn it off.
Oh,
Because are you also hearing me in real time?
washing my face.
Yes, sir.
Okay.
Does it look bad?
You guys hearing the delay?
Yeah, there's a lag.
That's wild.
This is a nightmare. Hearing myself like this.
Yeah, I believe so.
Muted or turn it off. Because are you also hearing me in real time?
Yes, sir.
Okay. You guys hearing the delay?
Yeah, there's a lag.
That's wild.
This is a nightmare. Are you also hearing me in real time?
Yes, sir.
All right, let's try something. I'm the only unmuted party right now. And let's see if that stopped the echo. Okay. Let's try something. I'm the only unmuted party right now. Why is that happening? And let's see if that stopped the echo. Okay. All right, we're streaming. This is live from Summit County. Cross-examination.
Yes, Your Honor. Mr. Renard, you performed this investigation to determine whether the defendant should get the life insurance policy payout, correct?
Yes, I determined if Summit Life should pay the claim.
And you did this because your boss directed you to.
Yes.
And your boss had some concerns about paying the defendant.
It's standard procedure to investigate any claim. Sometimes we go deep, sometimes we don't.
But your boss had two concerns about paying the defendant, correct?
Yes, again, it's $5 million. It's a lot of money, so we definitely want to make sure we do the right thing.
The first concern was that the defendant killed her husband.
It was something that we needed to look into in the event it did occur.
So that's a yes.
Yes.
And the second concern was that she forged Lou's will.
Yes.
Okay. I want to talk about your boss's first concern. You determined that he wasn't responsible for this disappearance.
That was through the generally done through the interviews we had, where we looked at some of the circumstances surrounding the disappearance as well as physical evidence found at the last known locations.
Right. And you determined through that investigation that she wasn't responsible.
Well, we determined that we would not hold her responsible in terms of paying the claim, that we had no evidence to deny it contractually.
And to make that conclusion, you wanted to be thorough in your investigation.
Of course.
To be thorough, you would want to look at all available evidence.
Yes.
You would want to talk to everybody available who had information, correct?
Yes.
And in fact, you asked the police department for information, correct?
Yes.
But they denied you access to all information?
Yes. My formal request to the police department was denied, correct?
Right. So you had to go to one of your inside contacts to get information.
Yes.
And we don't know here, no one here knows today who that inside contact is.
No, that is a personal source of mine, and I have to keep it private to ensure that flow of information kind of stays on. It's something that I rely on in a lot of investigations, not just this one.
So in your thorough report, you didn't put your inside contact's name, correct?
Correct.
And you're also aware that your inside contact works at the same place as the defendant's brother, correct?
Yes, yes.
And this inside contact didn't let you look at any evidence, did he?
Well, he communicated to me his evidence. I was not allowed into the station, into the evidence room or anything of the sort, as well as official reports. But the answer to the question would be yes.
So all you got from your inside contact was just word of mouth.
Correct. But it is something I've relied on in the past. But again, yes.
And the word of mouth was good enough for your thorough investigation.
He's a police officer. I'm a former police officer. We see eye to eye on these things, and in the past it's worked out. So yes.
I want to talk about some information that you got from the inside or your inside contact. You learned that the defendant had an alibi,
Yes.
and you learned that it was only for some time period covering the disappearance.
Yes.
And this part-time alibi was good enough for your thorough investigation.
Yes. I did not, get into the level of detail that I believe another officer as well as the defendant gets into in their depositions. But I did review those in preparation of today, and as well as preparation of playing my claim. And yes, they were sufficient.
And even though those were sufficient, you still never checked up on the alibi from the defendant, correct?
Correct.
Well, now I want to talk about another piece of information that you learned. You knew that the police were at the defendant's home, correct?
I'm not sure. Could you clarify the date?
In your in your report, you didn't clarify a date, but you were just aware in general that the police did go to the defendant's home, correct?
I believe so. I know for a fact they did go to Wild Wild Life, which is the defendant's place of work and where she owns. They may have searched her home as well, in just passing, but I believe the focus of the examination was at Wild Wild Life.
Right, and when they were at the Wild Wild Life, they tested her meat grinder?
Yes.
Objection, Your Honor, relevance.
Response.
Your Honor, relevance, if a fact is relevant, it has any tendency to prove a fact or prove a fact of consequence that's more or less probable. Here, this is talking about the defendant's, this is about the expert's investigation into the thoroughness of his investigation. He ruled the defendant out as a suspect. And if I may proffer, the testimony that I'm eliciting is that he ruled the defendant out as a suspect, even though he did not see any evidence or any results of DNA or anything police tested.
May I respond, Your Honor?
You may. And to clarify, the question here was just about a meat grinder. Is that right?
Correct, Your Honor. Yes.
May we hear that question again, just to be clear on what it was?
That he was aware that the police tested the defendant's meat grinder. I can clarify more so.
Yeah, Your Honor, we would still renew our relevance objection. Nowhere in direct did we mention a meat grinder. Nowhere in this case has there been a meat grinder mentioned.
Your Honor, if I may be heard, this expert in his report does specifically talk about the police testing the meat grinder.
Right, but I think you correctly stated the standard under 401 a moment ago, which is whether or not this makes a fact of consequence more or less likely. Whether or not it's been discussed yet in trial is not the standard for relevance. Arguably, that it hasn't come up yet is all the more reason for us to get into it now. If we start to get into expert testimony or something that this witness doesn't have personal knowledge about, Mr. Osborne, you can renew a different objection, but for now, I'm going to allow this under 401 as relevant.
Yes, Your Honor.
Mr. Renard, you are aware that the police tested the defendant's meat grinder for human DNA and blood, correct?
Yes.
And in your experience at the police department, if someone's meat grinder is being tested for human DNA and blood, they're probably a suspect, correct?
We never formally named anyone as a suspect in this case, but we do have to pursue all avenues. So the formal process of naming a suspect never occurred. You could use the term person of interest, but suspect, no.
But you don't know if that's correct or not, whether the formal process happened because you didn't get any evidence from the police, correct?
Well, the police never named it. I believe that's in both my report as well as the report of Taylor Pride that the police never named any suspects.
Even though you knew that they were testing her meat grinder, you just ruled her out as a suspect anyways.
Yes, yeah. The meat grinder, it could have been anyone at Wild Wildlife that harmed Mr. Donaldson. So I believe the police were just chasing down kind of any path, hearing any rumors and examining them.
Right. But you never saw the results from these tests, correct?
As far as I know, there was no human DNA found on that meat grinder.
Right now, I want to shift and talk about the second concern that your boss had about the will. You thought the wording in this will was suspicious.
Yeah, it's definitely unique.
And you compared the signature on the will to known samples of Lou's signature, correct?
Yes.
And you concluded that the known signatures were signed by the same person.
Yes, it seemed genuine.
And then you concluded that the known signatures were different than the signature on the will.
Yes, there's varieties in signatures.
But you concluded that there were differences.
Yes, no signature is going to be alike, and if every signature is alike, if it's identical, it's most likely a forgery.
But you concluded that two signatures were the same, but this one on the will was different, correct?
Yes, I would say all three were slightly different.
Based on your report, you said that the signature on the will, it's possible it was, it's possible someone tried to copy Lou's signature.
Yes.
You can't say whether the signature on the will was genuine or not, can you?
Correct. Inconclusive was my final ruling.
No further questions, Your Honor.
Redirect.
Mr. Nard, I just want to pick up on the will real quick. Does someone's handwriting change over time?
Yes.
What factors would that be?
There's many factors: age, health, care with signing, writing instrument, what you're writing on. There's a lot of reasons.
Was Lou Donaldson older when this signature that's in question was signed?
Yes.
Now, talking about the investigation, if there's no physical evidence, an expert in your field would have to rely on word of mouth?
Yes.
Did the police go to Wild Wildlife?
Yes.
Did the police find any evidence?
No.
Did the police go to Lou Donaldson's home?
Yes.
Did the police find any evidence?
No.
Did the police go to Wild Wildlife?
Yes.
Did the police find any evidence?
No.
Did the police inspect the meat grinder?
Yes.
Did they find any evidence of foul play surrounding that meat grinder?
No.
No further questions, Your Honor. May the witness be excused.
Yes, Your Honor. Is this witness under any subpoena from the plaintiff? Okay. You're released. Any other witnesses from the defense?
Yes, Your Honor. The defense calls Karen Baja.
Ms. Baja, raise your right hand. Did you do it?
Yes, it's up.
Oh, Yes.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, your witness, counsel.
Please introduce yourself to us.
My name is Karen Baja.
Miss Baja, I'm just going to ask you, did you kill your husband?
No, absolutely not.
Are you in any way, shape, or form responsible for your husband's disappearance?
Absolutely not.
Before we talk about what really happened, let's get to know you a little better. Where do you live?
I live in Pioneer County here in Statesville.
What do you do for a living?
I run Wild's Wild Life, which is a sanctuary for big cats. It's my absolute passion to care for animals, and I advocate for the protection of large animals. My work means so much to me.
How did you get involved with Wild's Wild Life?
Through my husband, Lou Donaldson, we love taking care of the big cats together.
I want to talk to you about your marriage with Lou Donaldson. How did you two meet?
Well, it's a funny story. Our love story all started one night when I was walking through town. Lou was sweet enough to pick me up. The rest was history.
Was Lou married before you two got together?
Yes, he was. He had a kid too, Cam, the plaintiff.
How do you perceive your relationship with the plaintiff?
I don't think he ever liked me.
Did Mr. Donaldson's family approve of your relationship?
No, not at all. Because my husband was 20 years older than me, a lot of people questioned our relationship. But the truth is, I was just a poor girl, and people were thinking that maybe I'm just with Lou for the money.
Objection. May we approach, Your Honor?
You may.
The witness's testimony is speculation.
Can you expand on that?
Yes, Your Honor. She is testifying about what other people think. She doesn't have personal knowledge as to what other people think about her.
Response?
Yes. One moment, please. Your objection was speculation?
Yes, counsel.
Yes. So Karen has personal knowledge of her family relationship. She was a part of the Donaldson family for years. And past that, this goes to why these claims were brought in the first place, which is her relationship with the plaintiff.
Okay. Overruled. Go ahead.
Let me re-ask that question. Did Lou Donaldson's family approve of your relationship?
No, not at all. He was 20 years older than me, so that made a lot of people question our relationship. I was just a poor girl, so his family thought I might just be with Lou for the money. But the truth is that Lou rescued me and took care of me. How could I not love him?
Ms. Baja, you heard here today that the plaintiff testified that Lou wanted to divorce you. Is that true?
It hurts me to say, but yes, we had talked about divorce before.
Why?
Well, he was always flying back and forth and spending too much time in Costa Rica, seeing other women, but we were working through it, or at least I thought we were working through it.
Ms. Baja, had you ever threatened your husband before his disappearance?
Absolutely not.
You mentioned Costa Rica. How did he get back and forth?
He flew his planes. He had a suspended license, but he would fly anyway. And he didn't always put his flight plans in, so he would stay off everyone's radar.
Was this something he did often?
Yes, he would take off at a moment's notice for business and other matters. He would always come back.
Let's talk about the weekend that your husband left and he did not come back. Was anything significant happening at Wild's Wildlife that weekend?
Yes, one of my tigers had just given birth to some tiger cubs, but was rejecting the cubs. So I was very focused on taking care of the babies.
Was there any point where you left the sanctuary?
Yes, in the early morning of August 18th, 2012, I had to run to the grocery store to get some milk for the cubs. When I was on my way back home, my car broke down. That was around 3 a.m.
How were you able to make it back to the sanctuary?
I flagged down a passing car and I used their phone to call my brother.
Why did you choose to call your brother rather than your husband?
Because my brother is a deputy sheriff. I knew he would be on patrol that night, so it was just easier that way. Plus, I was not even sure if my husband would be home, and I need to get back to those babies.
Why were you not sure if your husband would be home?
Like I said, sometimes he would just take spur of the moment flights.
Miss Baja, what did you do when you realized your husband might not be coming home?
I had my brother drive me to the airstrip where Lou's van had been found. The keys were still inside.
Objection 901. May I approach, Your Honor?
Amen.
Your Honor, specifically 901 chain of custody. I believe the counsel is eliciting testimony that the police had custody of this van per 901. A chain of custody must be established to if the item is non-unique, like a van or anything contained within a van, like keys or glasses. There has to be a chain of custody, and each person that had custody of that van or anything in the van of the non-unique item must testify to the time in which they had custody.
Response?
We're not trying to go that far into it. We're just, the police had called Karen and told her to come pick up her husband's van. It is, I would also argue that it is a unique item, as it was her husband's van. She's well acquainted with it, the dings, the scratches. She knows that that is her husband's van.
May I briefly respond, Your Honor?
You may.
Per the advisory note, something like a car that is reproduced, mass reproduced, is not a unique item. And per 901, a chain of custody, the counsel just stated that the police had custody of the van initially. Therefore, each police officer that had custody of that van and its whereabouts and the contents of that van must testify as to the custody in the time that they had it.
Okay, and to be clear, this witness is just testifying that she went and picked up the van. Is that right?
Yeah, she's testifying that when she got to the airstrip, Lou's van was present.
And she drove it home.
She's not even going to go that far. It's just that Lou's van was there and what she saw inside.
Okay, overruled.
Miss Baja, what did you do when you realized your husband might not be coming home?
I had my brother drive me to the airstrip where Lou's van had been found. Inside the van were Lou's glasses and his keys.
Why did you have your husband declared legally dead?
I hoped and prayed that he would return home safe. But with each passing year, it became more and more evident that was not going to happen. I thought having him declared would bring us all some much needed closure.
Why did you choose to do this on the 5-year anniversary of Lou's disappearance?
I had to keep the sanctuary up and running. That was Lou's dream. After 5 years of running it all by myself, I needed the money to support the Cubs.
Did you love your husband?
Of course, and I still do.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Ms. Baja, I want to talk to you about some things that you mentioned on direct. You weren't born to a rich family, right?
No, we didn't have much, but we had each other. That's all we really needed.
In your own words, you were poor growing up, correct?
Yeah, we didn't have much, but there's nothing wrong with that.
But that all changed when you met what you consider your Prince Charming, Lou Donaldson, right?
Sure, Lou was a hardworking man. That's why part of the reason I loved him so much.
And just like you mentioned, you met him hitchhiking.
Yes.
And you two quickly developed a relationship and fell in love.
Yes.
And got married.
Yes, we did.
I want to briefly talk about your relationship and your marriage with Lou. The two of you loved each other, but everything wasn't just great. You had some difficulties, right?
Of course, like any married couple.
In fact, as you know, and as you heard earlier, Lou asked for a divorce.
Yes, as I've said before, he did ask for a divorce, but we were working through it. We made vows to each other and we weren't going to give up on each other that easy.
In addition to this divorce, he actually filed a restraining order against you, correct?
Yes, and it was denied.
Right, but in your own words, that restraining order looked bad, right?
Sure, but it was denied because the court found no substance in it.
And you were in the courtroom earlier when you saw what day the restraining order was filed, and we can agree that the restraining order request was filed June 12th, right?
Yes, that's correct.
And according to you, he wrote a will leaving everything to you 2 days later, June 14th, right?
Yes, he did.
All right, I want to talk about this will briefly. This will gave everything that Lou had in his possession to you.
Yes, I was his wife.
But Lou signed this will, correct?
Yes.
And he's not the only one that signed the will, is he?
No, I was one of the witnesses, and there was additional witness.
So you were a witness to a will that leaves everything to you.
Yes.
All right. You mentioned Lou's trips and how he would take frequent trips. I want to briefly talk about that, and turn your attention to the early morning hours of August 18th. That morning, you were taking care of 2 tiger cubs, correct?
I don't know if it was 2, but I was taking care of the cubs. Yes.
Karen, in your own words, you mentioned that you were taking care of 2 tiger cubs, right?
Sure. 2 tiger cubs.
And according to you, at 3 o'clock in the morning, you realized that these tiger cubs needed milk and formula, right?
Yes. I mean, any babies, including tiger babies, they get hungry at unexpected times.
But these tiger babies ran out of milk at 3 o'clock in the morning. So you decided to go get formula from the store.
Yes.
And at 3 o'clock in the morning, you testified that at some point between Wild Wild Life and the store, your car breaks down.
Yes, that's right.
And at 3 o'clock in the morning, you step outside your car and start waving down people that are driving on the street, correct?
Yes, I was alone at 3 a.m. and I was scared. I needed to use someone's phone.
So you were alone and scared at 3 a.m., but you decided to use a stranger's phone, correct?
Yes, I had no option.
And let's talk about these options that you had. You made the option to call your brother, correct?
Yes, as I said before, my brother is a deputy sheriff.
Right, but you didn't call your husband, Lou, did you?
No, I didn't think that he would be home.
Well, Karen, if you made a quick call, you would have known if he was home or not, correct?
Sure, but I knew my brother would be on duty that night and he's a police officer, so he would know exactly what to do.
And you heard earlier that the 3 a.m. milk run that occurred August 18th is the same day that Lou was declared missing, right?
Yes.
All right, I want to briefly talk about what you got from the will and the insurance money. You had Lou declared dead August 18th, 2017.
Yes, that's right.
And that's exactly 5 years after he went missing, correct?
Yes.
And when you had him declared dead, you collected $5 million of life insurance money from his policy, right?
Yes, because I was the beneficiary. I was his spouse.
And we can agree that the same day that you had him declared dead is the same day that you filed the insurance claim to get the insurance money, correct?
Yes, like I said before, it had been 5 years of me running Wild Wild Life all by myself.
Okay, I want to talk about Wild Wild Life and how the investigation went to Wild Wild Life. Now, you heard earlier that the police did look at Wild Wild Life. They did investigate Wild Wild Life, correct?
Yes, I believe they did.
And as you know, the investigation to Lou's disappearance is currently ongoing.
Yes, that sounds correct.
And in your own words, the police looked into a meat grinder, correct?
Yes, it was a crazy claim, but they did investigate it.
And it's your position, it's your current position that you're not a suspect.
That is correct.
And you mentioned earlier that Lou would always come back from his trips, correct?
Yes.
But this time, he didn't come back, right?
No, sadly.
But you fired his son, Cam Donaldson, just 2 days after he disappeared, correct?
Yes, I did. As Cam has said before, we didn't have a good relationship with each other.
Now, your testimony earlier was that Lou took multiple trips and he did this all the time. Karen, did you ever fire Cam when Lou took these multiple trips?
No.
So this time, after Lou disappeared, 2 days later, that's when you fired Cam.
Yes.
No further questions.
Redirect examination.
Yes, Your Honor. You were asked about the Wild Wildlife meat grinder. Does the sanctuary have a meat grinder?
Yes, because it's necessary to process all the food for the cats. They eat a lot of meat.
Is processing the meat through the meat grinder messy?
Yes, very messy.
Do you know if the police checked for any evidence of a person being put through a meat grinder?
Yes, they did.
Was there any evidence found?
No.
Ms. Baja, how are you handling your marriage problems?
We were working through them.
And we just heard a temporary restraining order mentioned. What happened with that?
It was denied by the court.
Directing our attention to the will for a second, why do you think the will contained the language disappear?
Objection. May I approach, Your Honor?
You may.
This question calls for speculation.
May I respond?
You may.
This question clearly states, why do you think? She's not asserting anything as a fact. It's just what she thought.
And what do you think she's going to say?
That Lou was an eccentric man that took trips all around the world. So he wasn't the typical man that plotted a will. He provided for anything that could happen, the worst.
Your Honor, may I briefly respond?
You can.
Your Honor, this question calls her to speculate Lou's state of mind. She doesn't have information on his state of mind and why he would or would not say Dyer disappeared in the will.
Okay. I'm going to overrule the objection, but let's keep it limited to only what she can talk about from her own personal knowledge.
Yes, Your Honor. Directing our attention to the will, from your personal knowledge, why do you think the will contained the language disappear?
Like I said, Lou often flew around the world at a moment's notice. His planes weren't fancy and he didn't always log his flight plans. I think that he was planning for any sort of situation.
In directing our attention to the night where Lou Donaldson allegedly disappeared, why were you at the grocery store at 3 a.m? It's kind of a crazy time to be going grocery shopping.
Yes, I agree, but sadly, I can't control when the tiger gives birth.
And on your way back, why did you choose to call your brother?
Like I said, I knew he would be working that night. He's a deputy, so he always gets the graveyard shift. I was on the side of the road, scared and all by myself. It seemed like the fastest and safest solution.
And thinking back to the night where you and Lou first met, did you know he was rich, a millionaire?
No, there's no way I could have known that. It was really just love at first sight, and Lou used to drive an old beat up van.
No further questions, Your Honor. May this witness be excused?
No, she's the defendant. But she can come off the stand, but
Yeah.
she's going to have to stay here in the courtroom.
Come off the stand.
Yeah. Do you have any other witnesses from the defense?
No, Your Honor. The defense rests and asks that we be heard outside of the presence of the jury for motions.
Let's go straight into that now.
Okay. Your Honor, the defense renews its Rule 50 judgment as a matter of law. Viewing the evidence in the light most favorable to the plaintiff, no jury could find by the preponderance of the evidence that Karen Baja recklessly or intentionally caused the death of Lou Donaldson. The plaintiff has failed to produce any evidence to show how or when Mr. Donaldson even died, let alone an act of Karen Baja's that caused that.
Response?
Your Honor, entertaining a motion for summary judgment as a matter, or judgment as a matter of law, the court must consider all the evidence in the light most favorable to the non-moving party, which in this case is the plaintiff, and reserve any doubts in favor of that non-moving party. Today, we've presented evidence where a reasonable jury could find by preponderance of the evidence, which means that it's more likely than not that Karen actually is responsible and her intentional and reckless actions caused the death and disappearance of Lou Donaldson. We presented a death threat We presented a temporary restraining order, suspicious circumstances. Cam Donaldson got on the stand and explained the different events and the timeline that led him to believe that Karen Baja was responsible for Lou Donaldson's disappearance. We offered testimony from an expert witness. He substantiated all of Cam Donaldson's claims and presented his own expert testimony as far as the will and the legitimacy of that will. We have presented circumstantial evidence, but Your Honor, circumstantial evidence holds the same weight as direct evidence. Through circumstantial evidence that we've presented here today, a reasonable jury could find that the defendant's actions intentionally and recklessly caused the death or disappearance of Cam Donaldson, and Cam Donaldson was injured as part of those actions, and that he needs redress from those actions.
All right, I'm going to let this one go to the jury. So motion denied. We're going to move on to closing statements. Do the parties want a brief break to collect yourselves, talk amongst yourselves, that sort of thing?
Your Honor, can the defense have a point of clarification before closing?
Sure.
Would the court prefer the opposing counsel who is doing the closing to have their monitor on or off? I know that they were off during closing, that you turned them off during the opening. I didn't know if you wanted us to just go ahead and turn them off during closing, or wait for you to do that, or how we need to go about that.
I'll tell you what, whoever the two people are that are doing the closings, you can just have your cameras on the whole time. Everybody else will have their cameras off. That way you're still able to make extemporaneous objections if necessary. And I'll get back on just from an audio standpoint to make my rulings if there are any objections during closing, okay? And I won't mess with anybody's cameras. Can we get a time check real quick?
Your Honor, I have that the plaintiffs have 20 minutes and 40 seconds remaining, and that the defendant has 39 minutes remaining.
Okay. Don't take all that time. I think we're taking time with a grain of salt on this round anyways. But yeah, don't use it all if you can help it. And then we will constructively have discussed the jury instructions. I know that there was a piece that we had talked about when we entered a redacted exhibit. I like that you guys did that. That was a nice touch, but obviously we're not going to do a real instructions battle now. So I'm going to give you guys 8 minutes. Let's come back at 10:50 Mountain Time, and we'll proceed with closing arguments.
Thank you.
All right, is everybody back in the courtroom? Okay. We are back on the record in case number 082263, Cam Donaldson versus Karen Basia. We are proceeding to closing arguments. Is the plaintiff ready to proceed?
Yes, Your Honor, we are. And if I may, with whatever time I have left over, may I take a few minutes just for a rebuttal?
Yes, yes. Your remaining time will be reserved.
Thank you, Your Honor. Your Honor, may I proceed?
You may.
When all signs point to one conclusion, that conclusion is usually the right one. And today, all signs have pointed to just one conclusion. And that conclusion is that the defendant, Karen, has caused the death of Lou Donaldson. So I want to take you back to where it all began for the last time, when Karen was happy and hopeful. When she met Lou on the side of that road, she saw a home, prosperity, and a life that she could only dream of. But we fast forward to 2012 and Karen's no longer happy and hopeful. She's sad. She's angry. She's angry because Lou, her husband, has just told her that he wants a divorce. So Karen, desperate to maintain this lifestyle that she's become accustomed to, after she's realized that everything that she has, her home, her livelihood, her prosperity, is going to be all gone, she keeps a promise that she's disguised as a threat to kill Lou Donaldson. And on August 17, 2012, Lou Donaldson was seen alive for the very last time. Because Karen, she had a motive, she had a plan, and she executed that plan. And that's why we're here today. As the party bringing this case, we have the burden of proof. And that burden is something that we embrace. It is something that we have not run from. And it is something that we are confident that we have met today. We must prove to you by a preponderance of the evidence, meaning we just have to show you that it's more likely than not that 1, Lou Donaldson is dead. 2, the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. 3, the plaintiff, Cam Donaldson, suffered injuries, damages, or losses as a result of the death of Lou Donaldson. And 4, the defendant's conduct, either intentional or reckless, was the cause of the plaintiff's injuries and damages. So now I want to take you back to the facts and the evidence and the signs that you have all seen and heard today so that you and I can agree that all signs do point to just one conclusion and that all 4 of these elements have been met. So let's start with the first one. Lou Donaldson is dead. You heard today that on August 18th, 2017, the defendant requested a court to change Lou's status from missing to legally dead. And they granted that request. And then she walked out the front doors of the courthouse and walked through the front doors of Summit Life Insurance Company and cashed out Lou's $5 million life insurance policy the very same day that Lou was declared legally dead. So we know the first element has been met. So now, the second element, the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. Now for this element, I want to focus on the word cause because that's what this case really comes down to. And to show you that the defendant did cause the death of Lou Donaldson, we just have to look at her motive, her plan, and the execution of that plan. So let's first start with her motive. You heard today that the defendant came from a humbled upbringing. But when she met Lou, she got a taste of a more successful lifestyle. But as we all heard, Lou's love faded and he wanted a divorce. And you learned that she didn't take that very well because she threatened to kill him over it. And then Cam told you he has never seen his father so scared that his father felt the need to try to get a restraining order against the defendant. And that's when she knew Lou was serious. He was going to leave, and she was going to lose everything. So that's her motive. Maintain the lifestyle that she's become accustomed to. And now that she has her motive, she just needs a plan. So let's talk about her plan. She knows to ensure that she maintains that lifestyle that she's become accustomed to, she has to do something because Lou's done and he's leaving. So her wheels are turning, and she comes up with a 2-step plan. First step, a will for Lou that says she gets everything. Second step, make Lou disappear. Because with Lou gone and that will in place, she can take everything. So now that she has her motive and she's come up with her plan, she just has to execute that plan. So let's talk about how she executed the first step of her plan, that will. You heard today that Lou Donaldson supposedly signed a will, giving everything he has to the defendant just 2 days after he tried to get a restraining order against her, after she threatened to kill him, after he wanted a divorce. So, members of the jury, ask yourself, does this make sense? And what's more likely than not? Is it more likely than not that Lou Donaldson, who had a great relationship with his son Cam, just decided to leave everything he has to the defendant after the restraining order, after she threatened to kill him, after he wanted a divorce? No, that doesn't make sense. You heard from 2 experts today. Both of them analyzed that will. Our expert, Taylor Pride, and the defense expert, Chris Renard. And both experts agreed on some things. Both experts agreed that that will was a little suspicious. Both experts agreed that they've never seen the phrase die or disappear in a will. Both of our experts agreed that Lou Donaldson's signature on that will didn't match Lou Donaldson's signature anywhere else. In fact, our expert, Investigator Pride, told you that he was confident that that will was forged after he walked you through his extensive analysis of the signatures. The only thing you heard from the defense expert, Chris Renard, was that his findings were inconclusive. In fact, you heard him, he didn't really have a conclusion about any of those signatures. They were all different, he said. And I want to point out something that he brought up. He said that he wasn't able to tell much because of the age difference in between the signatures, but I want to point out that one of those signatures that he reviewed on the TRO, the temporary restraining order, was just 2 days before that will was signed. So age doesn't really have a play here today. They didn't give you an expert who could definitely tell you that that will was not forged. But we most certainly gave you one who said it was forged. So is it more likely than not that Lou signed that will? Or is it more likely than not that the defendant executed the first part of her plan? Look at the signs and look at where they point. So now that we know that she's executed the first part of her plan, she just has to execute the second part. Make Lou disappear, cause the death of Lou Donaldson. Now, to understand this, you just have to understand something that you will be instructed on, and that's circumstantial evidence. Circumstantial evidence holds the same weight as direct evidence. And all circumstantial evidence is different pieces of evidence, all different signs, pointing to one conclusion. And you heard a lot of those signs today that point to this conclusion. The will was one. And now I want to focus on another one, and that's the defendant's weak alibi. The defendant expects you to believe that the night her husband disappeared, she was getting milk for cats at the grocery store at 3 o'clock in the morning. Again, ask yourselves, does that make sense? What's more likely than not?
She told you that those cats had been born a few days ahead of time, that she was taking care of them. So is it more likely than not that she just realized at 3 a.m. that night she needed milk? No, that doesn't make sense. She's telling the truth, and these cats have been born for a few days and she'd been taking care of them. She would know before 3 o'clock in the morning that night that she needed more milk. So then ask yourselves, is it more likely than not that she went to the store at 3 a.m.? Is it more likely than not that she forgot her phone? Is it more likely than not that her car broke down? And is it more likely than not that she called her brother to come get her just because she wasn't sure if her husband was home? No, that does not make any sense. And the only person who can vouch for the defendant is her brother. But you didn't hear from him today. The defense didn't bring you anybody who can confirm the defendant's alibi. Their expert can't even confirm the defendant's alibi. He didn't follow up on it. He didn't follow up on that evidence. He didn't look at any reports. He didn't look at the DNA results from when the police tested the defendant's meat grinder. He can't tell you anything about the defendant. And all he got from his investigation came from this word of mouth from one of his buddies. One of his buddies that works at the same place as the defendant's brother. Ask yourselves, isn't it more likely than not that the defendant may have been a suspect when the police were checking her meat grinder and checking wildlife? Yes. And isn't it more likely than not that this inside source, his buddy that he got this information from, may not be so reliable? Yes. They really didn't give you an expert today who gave you a thorough investigation. Our expert, Taylor Pride, told you that all of the evidence that he looked at, the surrounding circumstances of the disappearance, the TRO, the will, everything, and all of the evidence and all of the signs pointed him to the conclusion that the defendant was responsible for Lou's disappearance. So based on all of that evidence, and based on everything that I've walked through, ask yourselves, is it more likely than not that this roadside grocery store pickup happened at 3 o'clock in the morning? No. What's more likely than not is that the defendant was in the process of getting rid of Lou Donaldson. We have showed you that it's more likely than not that the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. So we know that the second element has been met. So now, the third element. The plaintiff, Cam Donaldson, suffered injuries, damages, or losses as a result of the death of Lou Donaldson. For this one, just ask yourselves, did Cam suffer when he lost his father? Of course he did. His father was his best friend, his companion, and he worked for his dad for 20 years. So with his father gone, he lost his best friend, he lost his companion, he lost his job. And the defense came here today claiming that Cam is just seeking revenge and that he hates Karen. But Cam was honest with you today. He told you that he did hate Karen. But why wouldn't he? Karen was 20 years younger than his dad, married his dad, threatened to kill his dad. The evidence shows you that the defendant got rid of his dad. Then the defendant fired Cam and then took everything Cam's dad had. Of course he hates the defendant. Why wouldn't he? That doesn't make him greedy and just want money. That doesn't make him just seeking revenge. That makes him human. And humans suffer when their fathers and loved ones die. Of course, he suffered from injuries or damages or losses. So we know that this third element has been met. For the fourth and final element, the defendant's conduct, either intentional or reckless, was the cause of the plaintiff's injuries or damages. Well, for this one, it's just a domino effect, because we know that the defendant caused the death of Lou Donaldson. And we know that Cam certainly suffered from that death. So we know that the defendant's conduct, either intentional or reckless, most certainly was the cause of the plaintiff's injuries or damages. We have showed you that it is more likely than not that all 4 elements have been met. We have met our burden today. And because we have met our burden, when you go back to the jury room to deliberate, you must find for Cam. And when you find for Cam, you're going to have to decide how much the defendant owes Cam. And we can make this simple for you. Because of the defendant's conduct, she got the $5 million estate and the $5 million life insurance policy. Because of her 2-step plan, she got 2 things she didn't deserve. So give Cam $10 million, because we can't give Cam what he really wants, which is his dad back. And if his dad were here, the defendant, she wouldn't have that $5 million estate. She wouldn't have that $5 million life insurance policy. So give Cam $10 million because the defendant didn't deserve it in the first place. And you can do this because when all signs point to one conclusion, that conclusion is usually the right one. And today, all signs did point to just one conclusion. And that conclusion is that the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. And you, as a jury, you have the power to make this right conclusion. So we ask you, find that conclusion and find for Cam Donaldson. Thank you.
Closing argument from the defense.
Yes, Your Honor. This case was never about finding out what happened to Lou Donaldson. It was never about justice. It was never about Karen Baja. This case was about one thing and one thing only: money. Money the plaintiff felt that he was entitled to, but did not get. And because this case is about money, the plaintiff was never searching for answers. He was only seeking revenge. Seeking revenge against Karen Baja, against the woman that his father loved, against the woman that his father married. And because the plaintiff brought this suit today, he has approved by the greater weight of the evidence that Karen Baja caused the death of Lou Donaldson. The plaintiff has failed to show how Lou Donaldson died, when Lou Donaldson died, and most certainly, most importantly, that Karen Baja caused his death. Lou Donaldson disappeared on August 17th, 2012. And you heard today that he had a fleet of planes. So many planes that the plaintiff didn't even know how many he owned. And he would often fly to Costa Rica. The plaintiff even had to admit that. But what's even more important is that Lou Donaldson's pilot's license was suspended. And because of that, he would never log his flight plans, because he knew if he logged his flight plans, it would show up that somebody with an invalid license is flying a plane. And his plane would be grounded. Lou Donaldson flew where he wanted, when he wanted, without letting anyone know what was going on. And that's important because Lou's body was never found. Nobody knows what happened to Lou or how he died. Maybe he died flying to Costa Rica. You heard today that it was 2,200 miles from here to Costa Rica over nothing but ocean. And it would take 3 to 4 tanks of gas for his plane to even get there. Lou Donaldson was a secretive man. He met the love of his life, Karen, when he was driving around by himself one night. He did not ever log his flight plans, and he even had a mistress in Costa Rica. Maybe Lou Donaldson fell victim to that mistress. Maybe he was murdered somewhere in Costa Rica. Maybe Lou Donaldson's plane crashed in the ocean over 2,200 miles. Nothing but clear skies. Nobody knows how Lou Donaldson died. But everyone here today knows that Karen Baja did not cause his death. The plaintiff has failed to prove their case today. And because the plaintiff knows they cannot prove their case, they've made this entire trial about a will contest. And because they did, I need to talk about it. The plaintiff brought Taylor Pride in today, and Taylor Pride told you that 100% the will is forged. But let's think about Taylor Pride for a second. Taylor Pride was hired by the plaintiff, paid by the plaintiff, only spoke to the plaintiff, only looked at the evidence the plaintiff gave him. In closing, the plaintiff said that Chris Renard is untrustworthy because he relies on word of mouth. Taylor Pride, the only word of mouth Taylor Pride heard from was the plaintiff. I mean, give me a break. More importantly, you heard from Chris Renard, who was not hired by us, who was not paid by Ms. Baja. Chris Renard was hired by Summit Life Insurance Company to investigate whether Karen killed Lou and to make a recommendation as to whether they should pay Ms. Baja's claim. Summit Life even hired Chris Renard with the idea and initially thinking that Karen Baja had something to do with it. And Chris Renard pointed out to them that there was absolutely no evidence that Karen killed Lou. And they paid the claim. Think about that. We all know how insurance companies work. If there was even one single shred of evidence that Karen Baja caused the death of Lou Donaldson, Summit Life Insurance Company would have denied that claim in a New York minute. And the plaintiff knows it. The plaintiff has also made a big deal about the language in Mr. Donaldson's will. The language, if I should die or disappear. Now we admit, that is odd language for the ordinary man. But Lou Donaldson is not the ordinary man, ladies and gentlemen. Lou Donaldson owns a $5 million estate. Lou Donaldson owned multiple planes. Lou Donaldson would fly over 2,200 miles of ocean without letting anyone know where he was going. Do you know why Lou Donaldson put, if I should die or disappear, in his will? Because he was doing what any loving husband would do. He was protecting his wife, protecting the woman that he loved, looking out for wild wildlife, the sanctuary for cubs that Lou Donaldson and Karen Baja built together. They worked together to help succeed and prosper. Lou Donaldson might have been a secretive man, but he was also an intelligent man that loved his wife and made sure that no matter what he did, she would always be taken care of. The plaintiff has failed to prove their case today. The plaintiff is not searching for answers. They are only seeking revenge. So what's the plaintiff left with? Making allegations that Ms. Baja said some wild claims? It's true. Lou Donaldson did file for a restraining order. But that restraining order was denied. Denied in this county by a judge. It was not dismissed. It did not go to trial. It was denied. And the only reason that restraining order is denied is because a judge looked at it and found there was absolutely no merit to it. And it should not be trusted. That's the only reason a restraining order would be denied. But thinking about what the plaintiff has said today, it's important to consider the timeline. You know, the plaintiff called Cam Donaldson to talk to you about a timeline. Well, let's talk about Cam Donaldson's timeline. Cam Donaldson did not file this suit in 2012, 2013, 2014, did not get involved in this case until after the money was involved, until after Karen Baja received the estate. Cam Donaldson did not say one thing bad about Karen until after this lawsuit was filed, until after his deposition was taken. Days after his own father's disappearance, he was face to face with law enforcement officers, knowing good and well that they were conducting an investigation, did not say one thing. He makes these wild claims that Karen killed Lou. He did not say to the police, I think Karen's responsible. He did not say to the police, if something happened to my dad, look at Karen. Did not say one thing to the police. You know why? Because the money wasn't involved yet. Now, let's talk about the most important evidence you've heard today, or what I call the lack of evidence. Because sometimes, ladies and gentlemen, the fact that there is no evidence is the most important evidence. Days after Lou Donaldson's disappearance, the Pioneer County Sheriff's Department launched a full tilt investigation into trying to find him, had the full power and resources of the entire state, multiple police officers, multiple investigators, multiple investigations, did not find one piece of evidence showing that Karen Baja killed Lou Donaldson. Sheriff's Department inspected Lou's van. No DNA, no foul play, no evidence. The Sheriff's Department went to Wild Wildlife. No DNA, no foul play, no evidence. They went to Mr. Donaldson's home. No DNA, no foul play, no evidence. Ladies and gentlemen, the Sheriff's Department even took up this wild rumor, is the only best way to describe it, that Karen Baja threw Lou Donaldson inside of a meat grinder, that she just by herself tossed up a grown man into a meat grinder, and I guess he just let her do it. Well, the police also investigated that meat grinder. No evidence, no DNA, no blood, no sign of a struggle, nothing. I guess the plaintiff just wants you to believe that her and her brother, who's a sheriff's deputy, abducted Mr. Donaldson late one night, drug him in the back of a police car, drove him back to Wild Wildlife, and threw him in the meat grinder, then fed him to the tigers. That's the most ridiculous claim I've ever heard in my entire life. Months after Lou Donaldson's disappearance, the Sheriff's Department did not list Karen as a suspect, did not charge Karen, did not arrest Karen. 5 years after Lou's disappearance, did not list Karen as a suspect, did not charge Karen, did not arrest Karen. To this very day, as I'm speaking to you right now, the Sheriff's Department has not listed Karen as a suspect, charged Karen, or arrested Karen. The plaintiff has to prove that Karen Baja did something, anything to kill Lou Donaldson, some type of act. And all they've got is, well, she may or may not have threatened him 5 years ago. That's what they want you to believe. Fortunately, in this country, we do not find somebody liable because the plaintiff comes in here and makes some outlandish claims. We do not find somebody liable because the plaintiff is spreading rumors. We do not find somebody liable because the plaintiff is seeking revenge because he did not get the money he thought that he was entitled to. In our country, in our system of justice, we make everyone prove their case. The plaintiff has failed to prove theirs, failed to show how Lou Donaldson disappeared, failed to show when he disappeared, failed to show that Karen Baja caused his death. When you go back into the jury room today, the judge is going to show you two separate forms, Form A and Form B. The most logical form is Form B. It holds Karen Baja not liable. The plaintiff was never searching for answers. He was never searching for answers. He was only seeking revenge. That's all he has today, revenge. Revenge on his mind, and revenge is the reason this case was filed. Karen Baja is not liable. Find her not liable.
Rebuttal argument?
Yes, Your Honor. May I just shut off my camera real quick so I can set up my computer back up?
Yes.
members of the jury, we told you to look at the signs and look at where they point. And those signs still point to the conclusion that the defendant was the cause of Lou Donaldson's death. We showed you, or excuse me, the defense is still saying that these signs should point to Cam, but they don't. They still point to the defendant. And we showed you some of these signs. We showed you that there was an impending divorce. We showed you the death threats. We showed you the attempted temporary restraining order. And we showed you this new will supposedly being signed 2 days later. And then we showed you that Lou did disappear. And we showed you that Cam was fired just 2 days later. And the defense wants you to hold on to the fact that Lou was secretive and that Lou disappears all of the time on whatever trips he takes. Well, ask yourselves, what's more likely than not? Because those signs are very important in today's case. Because if he disappears all of the time, then why did this time he disappeared? The defendant took over the business. Why did this time he disappeared? She fired Cam. And why did this time he disappeared? She shows up with a will that says if he dies or disappears, she gets everything. Look at those signs and look at where they point. Because those signs point to the fact that it is more likely than not that the defendant did cause the death of Lou Donaldson. Thank you.
All right. That is a wrap. Let's all come back into the shot here for a second. Hello. Good job. Take a deep breath. You're done. Is that the end of the preliminary rounds?
Yes, we're just waiting till the final round now, I think.
All right, good. Well, you've worked hard to get to this point, I'm sure. There was 4 rounds total or 3 so far?
4.
4? Oof. Good work. I'm sure you're tired. Give us a second to put together our score sheets. I think that we need to do that first. And then do you want to stick around for some comments?
It's up to you, Your Honor. They haven't been giving us comments. I don't know if we're allowed to give them, but if you would like to give us some comments, I'd love to hear it.
Oh, I'd love to give you comments.
Thank you.
That's
comments are not allowed. Actually, they're not. You're supposed to only do them on the website, and otherwise they're not supposed to be making comments.
Got it. Okay, I appreciate you letting me know.
I'll send all good
the comment I did want to make, though, is that you did a very nice job. I appreciate that you guys were cordial to one another. This was a nice, clean round, and I applaud you for getting through to the end of these preliminary rounds. I know that can be a slog of sorts, but it's also exhilarating and fun, and you guys are learning a lot. So really hats off to you for taking the time to do this during this crazy pandemic. It shows a lot of strength of character and willpower that you guys are still getting this done while also fighting law school and this pandemic. So hats off to you. Appreciate you. Look forward to having you join the profession. Go throw some water on your face, take a break, loosen your tie, and good luck to you in the break rounds.
Thank you so much. Good job, guys. It was a pleasure.
Yeah, good job. Great. You guys have had the best evidence so far. It was crazy. Your evidence is so good.
I appreciate that. Y'all were as polished as ever, so I really thank you for that.
I was scrambling to my little miniature evidence notes. I was just like, I've got to look.
Tremendous work, guys. Nicely done.
Take care, everyone.
Bye, guys.